attorneys have been here today.
Morning.
Good morning.
Good morning.
Good morning.
All right. We'll introduce Judge Orfinger. I'm Judge Sawai, and to my left is Judge Ployce, who has graciously agreed to come sit with us today for this case. Each side will have 20 minutes. There's a clock on the podium, as you are aware, so we'll go ahead and proceed.
Good morning. My name is Jeffrey Jontz. I'm the attorney for the appellant. When an attorney does a good job for a client and gets paid a fair fee, all's right with the world. The client, the attorney, and the system all win. But when you have a situation like we have here, where the fees asked and granted are replete with what I term exaggeration, duplication, and invention, a term from the Miller case, in a way that I've not seen in my 40 years of practicing law, all sorts of bad things happened. The Colmans, the appellees, we think were taken advantage of initially by their lawyers. You will notice that they've replaced their counsel during the appeal in this case. Then my clients were taken advantage of when most of the fees and costs were shifted to us, and an appeal like this ensues. So the only winner here so far is the attorney who got the excessive fees. The clients and the system lost. When we first saw the Sasso attorney's fee request, we facetiously in our firms asked ourselves, where did we go wrong? We handled this small $350,000 one-issue case with one attorney and one paralegal for a little over $60,000, and frankly, we thought that was a lot of money for this case. We were astounded when we got the Sasso fee application asking for $287,000, and we asked ourselves, how could this have happened? So we began to take some discovery of the Sasso firm and its billing practices. And what we found out was that they claimed that they needed 3 17-year-plus lawyers working on this case. One trial lawyer, one 17-plus year researcher, and one lawyer who was also an architect.
Mr. Johnson,
Yeah?
the judge cut the attorney's fees by about 25% from what they were asking. And there's nothing that I could find in the record to indicate which hours he cut and so forth. He may have agreed with your argument that these other lawyers that worked on it really shouldn't be compensated. I don't know, because it's not clear in the record.
There's no findings on how he arrived at the numbers he arrived at.
But he did cut the number of hours, and our standard of review is abuse of discretion, and it's difficult for me to sit here and say, well, gee, I think this judge abused discretion. I wouldn't have given him that much, and maybe the other judges on the panel wouldn't, but still we're stuck with the fact that our standard of review is abuse of discretion.
Well,
and the same thing can be said about the paralegals too. I think the amount requested there was, well, I won't categorize it, but it was astounding to me anyway. But the judge cut it in half, and rightly so, I think.
Well, if you'll abide me a couple of minutes, I'll tell you why I think it's still an abuse of discretion. First of all, they asked for about 5 times what I think is reasonable, and when the judge cut it, it was now 4 times what was reasonable, but I think it's still unreasonable, and I think under the manifest injustice cases, which were first announced in the 4th DCA and which have been adopted in this.
But how do you decide what is manifest injustice? I mean, to what you may be manifest injustice is not going to be manifested injustice to somebody else. So I know your argument, and I've been in your position before, and so I can sympathize with it. But on the other hand, when it comes up here to the 5th DCA, it's very difficult for us to say that there was an abuse of discretion unless it's just really outrageous. We've had some that are outrageous. I mean, they would make this case look like nothing but.
Well, let me tell you in a couple of minutes here why I think this is still outrageous and why it still can be overturned on the manifest injustice, abuse of discretion basis. And let me tell you, when we began to take discovery of the Sasso firm, in addition to finding out that they had 3 very experienced lawyers working on a case that didn't really require it, We also found out that the firm claims to have no legal assistants, it has no secretaries, it has no word processors. Everybody in the firm, save a runner and an office manager, have been designated as paralegals, and they all bill to the file. So in this case, one small case that we handled with one lawyer and one paralegal and about 200 hours, they had 11 folks billing to the file, 1,200 hours. That's equivalent to having someone claiming to be working on this case 40 hours a week for 15 weeks. I will tell you, as a 40-year lawyer, clients come into my office and they say, what's this commercial litigation case likely to cost? And I, for many years, have said, I think you can use 20% of the amount in issue as a guidepost. So if it's $1 million case, you could spend up to $200,000 on it. We hope you wouldn't have that happen, but that's kind of a guidepost. And in this case, you'll see, we came in at right about 20%, which we thought was a lot. The Sasso firm asked for 80% of the amount in issue, and the court basically granted them about 68% of the amount in issue. So 3 to 4 times what they should have gotten.
John, let me ask you a question. Define the difference, or define a paralegal, and tell me what the difference is between a paralegal and a secretary. I think that's
important. For instance, at least in our office, and the way I know it to be, is if you give a complaint, or you give a file to someone and say, I want you to do a first draft of a complaint for me and let me look at it. Or I want you to go through this discovery and determine what our responses should be and make me a first draft. Those are sort of para-professional functions. If you'll look at the Sasso attorney's fee request, it is replete with opening the mail, putting the mail on Mr. Sasso's desk for his review, posting things to the file, things that are clearly clerical. The case law and the ethics opinions say attorneys can bill for their time, paraprofessionals can bill for things that are truly paraprofessional. But the work of clerical people, I mean, it's an important job.
Give me a definition that if we wanted to instruct circuit judges in the future, the difference between a secretary and a paralegal. How would you articulate that?
Functions which do not require legal training to perform. For instance, a secretary or a legal assistant, whatever we call those folks today, can type a letter, whether they really know anything about the law or not. They can file in a file, whether they know anything or not. They can make copies. They can collate. They can do all of those kinds of things. A paraprofessional is normally someone who has had some kind of legal training. They've either gone to a paraprofessional course. They have worked in a title company. They have done something that would give them quasi-legal training.
Isn't it really more of a functional analysis? If you look at 57104, which authorizes the court to allow fees for paralegals, it functions on, a legal assistant performing legal research, case development, planning, modifications, services, prepares or interprets legal documents, or selects, compiles, and uses information from encyclopedias or practice manuals. I mean, isn't it really what they're doing as it more so than who they are?
Yes, but I mean, as an example, if I take someone who has 2 years of paralegal training at UCF or some school, and I say, go to the library and do some research for me, they have had some training in doing that. I don't think I would ever send a secretary or a legal assistant to the library and say, I want you to do some legal research for me, because they wouldn't know what they were doing. I'd be wasting their time and the client's time.
Well, but likewise, in a less technical area, an experienced legal secretary, if you said draft a complaint for auto negligence, an experienced legal secretary can probably do that. So it seems to me more of a functional analysis
Yes.
more than anything else. I guess the difficulty that I have here is really one that it's very difficult to say what I think it was Judge Whitehead.
It was.
What he accepted and what he didn't, what he included and what he didn't. And on the one hand, I don't really want to I wouldn't want to send the case back and say, well, you've got to list every entry that you're approving. But on the other hand, I'm sensitive to the idea that fees are a very sensitive area for the courts,
yeah.
and that we ought to take our responsibilities seriously in that respect. Let me just ask one clarifying point. The counterclaim that was brought by Landmark, by the Colmans, by Landmark.
They sued us.
Right, by Landmark. Did you all sue for simply to retain the deposit, or did you sue for any kind of contractual right beyond that?
No, there was no intent to require the Colmans to specifically perform the contract.
And so what did they have at risk other than fees? They had their
$350,000,
of which they'd put up $175 in cash and a promissory note for the other $175.
After we lost the case at the trial level, we decided it wasn't worth appealing it. We gave them back their $175,000, and we canceled their note and gave it back to them. So and from day one, everybody knew this was a $350,000 case.
Let me just ask you this way. If we remand this case, what do we tell Judge Whitehead?
Okay.
Do we tell him that you've got to shave another 25% off? I mean, that's using our discretion and substituting it for his discretion, it seems to me.
Yeah.
We don't do that.
In the Miller case, which started the whole manifest injustice series of cases, that was a case where they got about $240,000 from the trial court, and the Fourth DCA sent it back and said a fee in excess of $8,000 cannot be justified. That's pretty extreme. I don't know that I'd tell you.
I'm not sure I would agree.
Yeah, I understand. But let me tell you what I think you do. First of all, the plaintiff proceeded in this case, or the Colman, Sasso, proceeded to put on attorney's fee expert testimony in which they put forward what I call everybody who touches the file bills the file theory. Their expert testified that in today's modern the business model for the attorney in most major firms now is to recoup the overhead directly to particular client's file, and so every task that is performed within the firm is charged to one client, file, or another. I think that's emphatically not Florida law. So here's what my suggestion is that you do. Because the question always is, what do you want us to accomplish? One, you announce clearly that the standard advanced by the plaintiff is not the proper standard. Clerical functions are not compensable no matter what you call the people doing them. The standard is reasonable work done by a reasonable number of people working a reasonable amount of time. The standard is that real paralegals doing real paralegal work is compensable, but nothing else.
How do we know that's not what Judge Whitehead did?
Well, let me tell you.
I mean, I don't want to send it back and say, gee, Judge Whitehead, this is what you're supposed to do, and he's reading this saying, that's exactly what I did do.
If you look in something really kind of unusual happened in the Miller case. Judge Schwartz, two things came out of that case. One, Judge Schwartz has a sense of humor. Because he said in that case, I'm going to use Judge Potter Stewart's famous quote in the pornography case to tell you how we feel about this case. And that's the famous one about, I don't know how to define it, but I know it when I see it.
Let me ask you about some of the findings. And since we're on paralegals, we'll stick with them. The trial court found that the paralegals reasonably spent 300 hours of time in working on this case. I assume that the judge heard all the evidence and testimony and came to that conclusion based on that, didn't he?
Well,
Are we supposed to just set that finding aside and come up with our own number of hours?
well, I can tell you that in the Miller case, the Ziontz, Z-I-O-N-T-Z case, and your Progressive Insurance case, in all three of those cases, the Patients Fund Row calculations had been made by the trial court. And so we have to assume in all of those cases, somebody had sat down and tried to calculate reasonable hours and reasonable fees, and those were all set aside on the manifest injustice theory.
So you're saying that you don't have anything to argue in terms of 300 hours not being the number of hours that were expended. You're just saying it's just unfair.
Well, our experts...
Is that basically what you're saying?
Our two experts, both of whom had tried numerous cases on this exact point, the ability to rescind a condo contract, which is pretty popular litigation these days. I think Mr. Spivey testified that he'd either tried or was handling about 80 of these cases, certainly dozens of them. And they both testified that these numbers are way out of whack for what is a garden variety.
The trial judge heard all of that, and so, I think this is a finding of fact. He's saying 300 hours is what I find that they reasonably expended at an hourly rate of $125 per hour. So he heard the testimony on both sides from all the witnesses and came to that conclusion. I understand your argument to be that, well, it's just not fair. So, we disregard that finding of 300 hours times 125 and come up with what we think is an appropriate number based on fairness?
No, what I'm saying is that the evidence is, I think, that 750 hours of awarded time, 450 hours of legal time by 3 17-plus-year lawyers, and 300 hours by 8 paralegals is excessive, and a finding that many hours is reasonable on this record.
Was there evidence presented upon which the trial court could properly make these findings?
Well, the
and
answer...
that also goes to the 450 hours that he found in terms of the attorney reasonably expending their time and effort at an hourly rate of 350. I mean, was there evidence presented where the trial court could say, yes, I believe this evidence and testimony, and this is what I'm basing my findings on?
The plaintiff's expert testified that he believed 1,200 hours was reasonable. So is there something in the record in which he could possibly make this finding? Yes. Then he was asked about the standard under which he thought these kind of fees could be awarded, and that's when he made what I thought was an astounding statement, that today's billing model in a law firm is that everybody who touches the file bills the file.
Okay, so I just want to make sure I'm getting your argument straight. You're basically telling us that there's substantial competent evidence for the findings made by the trial court that based on 450 at $350 per hour, and then for the paralegals 300 at $125 an hour. Your basic argument is, despite that, despite those findings, we should say that that's just unfair and it's just too high based on fairness principles. Is that your argument?
Well, not really, because in the Miller, Zantz, and Progressive Insurance cases, I think in all those cases there was testimony that supported the judge's findings. And in each of those cases, this court said that's just manifestly unjust. We know
manifest injustice basically based on fairness. I mean, we just say that it's just too high and it's not fair. It's not right.
Well, fairness is such a Jello-type concept. But in those cases, they said, in relation to the size of the case, the amount in issue, this award is just way out of line with what it ought to be if the proper Florida case law and ethical... Do you have a
number that you think is fair that you want us to put into an opinion, or should we remand it back and say, well, Judge, you have to base this on, the trial judge, you have to base this on manifest injustice and do what's right and fair, and this is just too high, and start all over again?
I know what you to do. What I want you to do is send the case back, tell the court everybody who touches the file is not, bills the file is not the standard, and that the only competent testimony because it's the only testimony in the record based on the correct standard is the evidence put on by the defendant's two experts, Mr. Scambus and Mr. Spivey, one of whom testified that he'd handled several of these cases and he thought $75,000 was a fair fee. Mr. Spivey testified he'd handled dozens of these cases and a range of $60,000 to $90,000 was a fair fee. So I think you would send the case back and say this award is manifestly unjust. You could go as far as the Miller case and put brackets around it, or you could send it back and say the competent evidence was that adduced by the defendants.
Counsel, I think that you would agree that the Miller case, the Zions case, and the Progressive case tend to be the outliers as opposed to the normal rule. I mean, the normal rule, I think, is you would agree that we almost always defer to the trial judge on these matters, unless it's just so bad, you know, you have to hold your nose to do something with it. And, you know, the difficulty I have with these cases, and you know, candidly, when we ask you questions about manifest injustice and abuse of discretion and fairness and all, I mean, it really comes down, in my mind, to the old smell test. It either smells right or it doesn't. Now, some of them stink so badly that you just can't be in the room with it, and you've got to take care of business. And some of them just smell, and you just have to say, well, you know, this is way out at the edge, and you know, I think, frankly, in my mind, I tend to agree with you that I think the business, and I know Mr. Sasso, I've litigated cases with him as a trial judge, he's a great lawyer, but I don't think the business model that he's using, that, you know, everybody that walked by the file gets to bill it, is one that is, that may be the deal between he and his client, but it isn't one that I think you can make the other side pay for. The difficulty is whether Judge Whitehead took all that into account, and you know, and I'm a firm believer, as I wrote in the Progressive case, that there, in most instances, needs to be some relationship to the amount in controversy and the effort expended. And of course, you look at the facts of the Progressive case, and it was, you know, $1,300, and it worked out to an attorney's fee of, I forget.
Am I allowed to respond, or is my time expired?
Go ahead and respond, and then we'll give her
You
some
may
extra
remember in your Kensington case, City of Orlando versus Kensington case, which is cited in our brief, you said in that case, initially, the contract between the lawyer and the client is their business. And what they decide may be reasonable as between them. But when you then try to shift it to somebody else who wasn't a party to that contract, that fee may become unreasonable. And that's kind of what we have here. If this fee had never gotten transferred to us, it would have just been the Coleman's business. But once they tried to transfer 3 or 4 times the reasonable fee to us, then it became our business. And so you might look at the Kensington case and then the Miller, Zantz, and Progressive case as a way to craft an opinion in our favor.
Okay, you've gone 3 minutes over, so I'll give you 3 extra minutes
Thank
if
you,
you
Judge.
want. Okay, thank you.
May it please the Court, Counsel. My name is Andrea Manthorn. I'm appearing on behalf of the Colmans. Your Honors, there are 3 reasons why this Court should affirm the trial court's final judgment.
Counsel, before you get into your argument, I want to clarify something. There's a statement in the brief that was prepared by Mr. Johns that the court erred in awarding costs in the amount of $22,709, and then he lists certain costs. And in picking up the wallet on this thing, there's a summary of expenses with that total amount on it that seems to be different from what he's stating. But I'd like to go through some of these things and see whether these are items at the cost items that the court actually considered. Would you indulge me in that for a moment?
Yes, Your Honor, if you could direct me to
for
the page.
example, he refers to photocopying and postage charges in the amount of $7,335.26 and $122.99 respectively. I don't find that anywhere on this other summary of expenses that I've got. I'm in a quandary as to which one it was considered by the judge and which one was found to be. There's some other things like after-hours heating and air conditioning, $420, and meals, $145.57. And I don't know whether those are ones that were included in the 22,709.83 or not.
Okay, could you direct me to the page you're referring to in the initial brief?
It's Mr. Johnson's brief, page 31. That may have been an argument that he was making, but and I don't know where this particular page came from, which has on it summary of expenses with a total of 22,709.83.
It has a Bates stamp of 3507, so I assume that's where it was in the record.
And I don't have a copy of that other page
You
you're
don't have a
referring
copy
to
of
as
Mr.
well.
Johnson's brief?
I have the copy of the brief, but I don't have a copy of the other page that you're referring to match
Well,
up.
this is, when I arrived, this is the first time I've seen this. It wasn't attached to the law clerk's memorandum on it. Do you have that page on yours?
I don't know. Do you have it?
Is it this page?
Yeah, that's what I'm looking at. Yeah.
Just give it to,
Approach the bench and take this, and I don't know whether you've seen that or not.
Thank you, Your Honor.
do you really think that heating and meal expenses are reimbursable under the uniform guidelines or under any other rule that I've ever heard of?
No, Your Honor. Those costs are discretionary, and if the court abuses discretion on some of the costs, we're not here to argue those costs. If those costs should be stricken, if the court abuses discretion on some of the costs.
I mean, the problem is we can't tell what the court
We can't.
did or
Exactly.
didn't do. I mean, there was a lot of those costs that I thought, and I realized that the costs are a small part, but I've just never seen anybody put in for, I assume that's either after hours or turning on the heat or the air conditioning in the building and meals, overtime for people and that sort of thing. I mean,
We do, let's see, there are some of the costs that were objected to and preserved, and we're not sure about some of the costs.
well, I know you didn't write the brief, but I must tell you that the argument on the cost issue, while succinct, wasn't very illuminating. The argument was the court didn't abuse his discretion, thank you. And while I appreciate brevity, it didn't really help us a whole lot.
The bigger issue, Your Honor, is the attorney's fees.
You don't mind if we just strike all the costs?
No, Your Honor. The bigger issue.
How much did the cost, do you know how much we're talking about here? Because I haven't added it up.
For costs, it's $22,000.
Pardon?
$22,000 in costs.
Judge Orfinger just asked you, do you mind if we strike the costs? And you said no. So you don't mind if we strike $22,000 in costs?
Well, it's...
Is that, I'm not sure I understand what you're saying here.
It's...
Are you conceding all the costs?
I don't think it's all of the costs. I think some of the costs are, I apologize, Your Honor. I think some of the costs are legitimate. I
think they are too. The problem
Yes.
that I have with the brief is it would have been helpful, and again, I understand you didn't write the brief, but
And I apologize, Your Honor.
it would have been
I wrote it,
helpful.
I assisted in the brief with Mr. Campbell, so I don't want to mislead you.
I appreciate you taking part of the heat. It would have been helpful if the brief would have said, you had plenty of pages left, if you would have said, these costs fit in under the uniform guidelines under the shall be taxed category. these costs fit into under the may be taxed, and this is why we think the trial court was correct in taxing them. And these we probably should have never asked for, and we don't have a good argument.
Right.
Other than saying-
That would have been a better approach.
There was no abuse of
We could see
discretion. Thank you so very much.
And if we had, it would have been better if they had been outlined for you which ones would have been appropriately taxed and which ones would have been appropriately.
Let's move on to the main event, which is the attorney's fee. So
Okay.
we've got a dispute here involving essentially $350,000 breach of contract. And the case itself doesn't seem particularly remarkable. You got a set of condo docs, they make changes, you say, oh, these changes are material, they say, oh, no, they're not. Everybody has some experts come in and the documents say what they are, and 2.5-day trial, and the court says, you win. That's what the fight was about, right?
Well, Your Honor, we don't know exactly what the fight was about. And, Your Honor, I think that's one of the important things to consider, is that the trial court was the tribunal that sat on the underlying trial. And Mr. Sasso pointed out, as part of his closing argument at the motion for attorney's fees, is, Your Honor, let's not forget here, you were the tribunal that sat through this trial, and the defense's experts are arguing that this is not a complex case, and I beg to differ with you. These are the issues that were presented at the trial.
Well, but I mean, the bottom line is, what the fight was about was, I mean, the condo docs say whatever they say, they made changes, you say the changes were material, letting us bail out, they say, oh, no, they weren't, and the court agreed with you. I mean, that was the fight.
And apparently there were some other issues that arose at trial. There were apparently some other issues that were regarding retroactivity of a statute, and Mr. Sasso brought that issue up, and the court was the appropriate party or the appropriate entity to determine whether or not there was merit to the argument of how complex this trial actually was, and whether it was or was not cookie cutter.
So the case, though, the court ultimately approves 450 hours of attorney time, is that right?
Correct.
And assuming a 40-hour work week, 40 billable hours, I know when I was in practice I might work 60 to get 30 billable hours, or 40, but be that as it may, to get 40 billable hours, I mean, that's 11 weeks working nothing but this case. If one attorney worked 40 hours a week for 11 weeks, that's the number of hours. Just seems, I mean, intuitively, having been a practicing lawyer, a trial judge, and now doing this, intuitively that seems like an awful lot of time for what, at the end of the day, I mean, it seems to be you put the documents in and everybody, they say what they say. There can't be a fight about that. And the experts come in and say whatever they say, and trial judge decides. 2.5-day non-jury trial. Just seems like there has to be some relation. Do you agree with what we said in, well, we didn't say it, we quoted an observation from a 4th District case that there is or should be an economic relationship to almost every legal service in the marketplace. The value of any professional service is almost always a function of its relationship to something else, for example, some property or other right. In other words, nobody in their right mind would spend $1 million to recover 1,000.
Of course.
No, and this case certainly doesn't come close to that, but I guess my question is, do you think, just as a matter of fundamental common sense, that in most cases there needs to be some rational relationship to whatever it is you're trying to achieve and the effort that you're willing to expend to achieve it?
Of course, as a general proposition, yes.
And is there anything about this case that would make it some exception to that general rule. Now, I'm not asking you to concede that this case, that there isn't that relationship. I'm just asking you if there's anything that's unusual about this case that would take it outside that general framework, that there ought to be some relationship between what the fight is about, what you're trying to achieve, and what you're willing to expend.
No.
Okay.
No, but I would say it's not outside of that.
Okay. So really what this case comes down to, I guess, from our review, is kind of what I told opposing counsel, is this fee so out of line that it falls into the outlier category of the three cases that he quoted, or is it either on its face reasonable or not so bad that we can't say that the trial court abused its discretion? I mean, would you agree that if you were sitting in our shoes, that's more or less the analysis that you have to do?
I would agree, Your Honor, that is the analysis. And I would say that it does not fall outside of that general proposition, and here's why, Your Honor. The case was over an approximately a year-long preparation for trial, and that it started out as a $1.7 million case. Mr. Sasso didn't know that it was going to, in the end, going to be a $350,000 return.
Well, he knew that when they filed their counterclaim and they didn't seek specific performance, they were just trying to forfeit your deposit and promissory note.
That was at the last minute, Your Honor. He had to prepare the case as though it was going to be a
Did they ever raise did they assert a counterclaim seeking specific performance?
I believe they did, Your Honor. I believe they did.
Okay, well, I'll have to go back and check, because I didn't, I mean, that's why I asked the question. I thought that their counterclaim was just for, they wanted to keep your deposit and the collect on the note, but.
I believe that was the testimony at the motion at the hearing on the motion for attorney's fees.
Do you think that if a paralegal, if a person, forget what we call the person, if a person opens the mail, scans it into the system, puts a note on it on the lawyer's desk that says, this is a discovery request, your answers are due in 20 days. Is that clerical or is that paralegal work?
I think it entirely depends, Your Honor. I think it comes down to what you said during Mr. Johnson's argument. I think based on what you described, I would call it a administrative function. If there is anything that is more...
Well, if you're the circuit judge and the testimony is, person A opened the mail, read the mail, looked at the mail, scanned it into the system, and tickled it for 20 days, put it on attorney's desk with a note that says, answers to these requests for admissions are due on such and such a date. Is that paralegal that would be compensable or clerical that would not be compensable?
I think it's possible that could involve an analytical function that could be considered a paralegal billable hour, a billable chargeable time, if it's a reasonable amount of time. However, it is also possible that is completely an administrative function. And I think that goes back to what you were describing when you were talking to Mr. Johns. It's a matter of what their function is and not who they are. And it also goes back to what Mr. Sasso's testimony was.
I guess I have a hard time with the idea that opening the mail is ever anything other than a clerical function.
And I agree with that.
Or putting a note on the thing that says, these are requests for admissions, you know, this has been tickled for 20 days or whatever. Now, if the lawyer hands it back and says, okay, put together a first draft of our responses, that's a different ballgame. But I have a very hard time. I don't care if you call the person, the managing partner. I don't think they get paid $350 an hour if they put on their timesheet, I open the mail, or I'm going to the post office to pick up the mail.
I agree with that. I agree with that, Your Honor, and I think it becomes very difficult, and I think we run into this with lawyers as well, when lawyers draft letters to clients. If it says, this is to confirm our meeting when we talked on the phone, our meeting for tomorrow at 3 o'clock, do they bill for that or not? It doesn't matter who you are. It's a functional analysis. It matters what is it that you are doing. It doesn't matter what your training is.
Well, how do we determine, I think you and I are probably on the same page, that it's a functional analysis, and it doesn't really make any difference if the janitor is performing what you and I might agree is paralegal work and doing it competently, that the janitor can bill for that. And likewise, if the managing partner is doing something that, he wants to spend the afternoon filing papers, nobody's going to pay him $350 an hour to do that. How do we determine, though, from the findings or lack of findings made by the trial judge here, whether the judge considered those things and how he exercised his discretion? All we know is you asked for X, you got X minus a certain percentage.
I think what you look to is the standard of review on appeal, which is an abuse of discretion, and whether there is competent, substantial evidence in the record, and that's what you have. You look to the evidence that's in the record. You have Mr. Sasso's testimony, which is, I do not bill for purely administrative functions. I do not, and he explained that. He said when somebody picks up a file, and I have paralegals, and they do both secretarial work, they do paralegal work, and when they do purely secretarial work, I don't bill for that. And when they do their paralegal work, that's when they charge for it. Now, I think most lawyers, when they write out their invoices, they do somewhat cryptic descriptions of what they did. And I think what we have here are somewhat cryptic descriptions, open mail or scanned documents. And unfortunately, that doesn't entirely explain what he did. But he did describe it in the testimony. We then have Mr. Freeman, who further described it. They carried their burden. The problem is, with Mr. Johnson's burden, he didn't carry the burden. He didn't then shift the burden and properly and dispute and refute that evidence. The further problem with Mr. Johnson's burden is that or on appeal in particular, is that the trial court did just what it was supposed to do. It cut the hours. So we have 300 hours of 600. It cut half of the paralegal hours. And so this court can look at the entire record and say, and determine that, well, the court did one of two things. It either made a factual finding that, well, Mr. Sasso, the trial court either determined that the reasonable number of hours the paralegals spent on this case were 300, which is one of the row factors it's supposed to determine, or it didn't buy the argument, and it determined that opening the mail wasn't a purely clerical, wasn't a paralegal function, and was purely clerical, and it cut those hours out. This competence is substantial evidence in the record for this court to make that determination.
Thank you very much.
Mr. Jones.
You don't have any rebuttal time, and you want...
I got a question.
Okay, come on up, if he has a question.
Can you clarify for me why your brief has certain items in it that don't seem to jibe with the summary of expenses that apparently was computed by the trial judge? The total is 22,709.83, and none of the items on here seem to match what you've alleged in your brief.
I think probably the honest answer, as I said here...
You may not have that. Could you share that with them?
Can I say that?
Because I think that's what Judge Ployce is looking at and trying to compare that to what was in...
Where did that come from? I assume it was part of the final judgment, wasn't it?
To be honest, I don't know.
Where did you come up with your numbers in your brief?
Well, the bottom number in the number on this exhibit, 3507, is $22,709.83, and that's the same number that is in our brief. We say that...
It's the same number, but the ingredients are different. For example, you got online research in the amount of $216. I don't see any online research here other than a $21.60.
Let me tell you what I think may have happened, but I'm not completely sure.
Maybe in a different category on that list, I don't know.
Yeah.
I don't know
Mr.
where it
Sasso
went.
filed a fee application, and then he filed an amended fee application. And it may be that this came from the first application, and on the amended application, the numbers are different, but the total at the bottom, 22,709.83, is the same. So that's, as I stand here today, that's the only thing I can tell you.
I mean, I don't have too much of a quarrel with the items that are summary of expenses here. They seem to be arguably allowable within the discretion of the court. But then you come up with some different numbers here that I can't make heads or tails out of.
I think fairness indicates that I tell you that we didn't object to all the costs. We only objected to $14,609.98. And those are laid out specifically on pages 31, 32, 33, and 34.
So these are the ones that you've listed here are ones that were not allowed by the court. Is that what you're saying?
No, what I'm saying is on page 31, 32, 33, 34 are what we understood the court to have allowed that we think are non-allowable in those amounts.
And you think that we may have the original cost application, and you say there was an amended one. We'll just go back and look at the record to see.
Yeah, I mean, fairness indicates that they asked for $22,709.83, and we agreed that $8,099.85 was okay. And there was about $14,500 that we thought weren't right, and those are specified specifically on pages 31 through 34.
Okay. Any
Thank
other
you.
questions? Okay, thank you both very much.
Thank you.